Mr. Barak. Okay. There you go. You started off pretty far away, Mr. There you are. Good.
Thank you.
Okay, Mr. Barak, you're up.
May it please the court, Ryan Barrick, Paul Barrick Nadu, on behalf of John Godwin, appellant, petitioner, and defendant below, I'd like to reserve 5 minutes for rebuttal.
Sure.
This is a case about the anti-SLAPP law. We were previously before this court, and the court remanded the matter back to the trial court. Unfortunately, the trial court made errors in evaluating the SLAPP motion again and denied Mr. Godwin's anti-SLAPP motion. While the matter was pending at this court, the Florida Supreme Court issued its decision in Verariker versus Powell. Verariker resolved the conflict and created a new interlocutory appeal vehicle for denials of anti-SLAPP motions. As a pipeline case, Mr. Godwin should get the benefit of this new understanding of the law, and the new law shows that this court should again reverse the trial court's denial of Mr. Godwin's anti-SLAPP motion.
Mr. Barak,
Yes.
Are you aware of the Love versus State case from the Florida Supreme Court that talks about the temporal reach of new procedural enactments?
I can't say that I've specifically reviewed that case, Judge Moe.
Okay, so if I represent to you that the Florida Supreme Court has said that a new procedural rule applies to pending cases as long as the posture of the case permits it, this is a new rule of procedure, right?
Yes, Your Honor.
Okay, and this case was pending at the time that the rule took effect, right?
Correct.
The Florida Supreme Court made it effective immediately, right?
Right.
Upon release of that opinion, actually. So it was about as fast as a rule could take effect, and the event to which the rule would apply had not yet happened at the time that the rule took effect, right?
The event to which the rule, correct. There was no rule that existed at the time of the trial court's order.
Okay. I mean, I think that helps your argument. So, Mr. Geisler, I just wanted to make sure that you're aware that I'll have the same question for you.
Yeah, and Judge Moe, I mean, clearly, we don't have a time machine to go back in time, and that's exactly it, right? We have to get the benefit of that new rule because there was no way for him to have filed the document. Now, to be clear, what he did do is he filed a petition for a writ of cert. And under the court's standards, under Appellate Rule 9.040C, the court can convert things as necessary to advance the interest of justice, right? And there are cases like the Stopa case, which we cite in our materials, where the court said this was originally brought as a petition for writ, but we think it's more appropriate to review it as a non-final order. And so the interest of justice absolutely allowed the conversion of petitions for writs into non-final appeals. And in this case, that's absolutely what makes sense because there was no mechanism to do it at the time. I would have been subject to sanctions because I would be citing a non-existent rule. I'd also note that this case is a little different from Verariker, which also helps us because here in Verariker, the Florida Supreme Court specifically said, essentially, there was no claim that the trial court didn't follow a procedural non-discretionary requirements of the anti-SLAPP rule. Here, we are saying that they didn't follow the requirements of the anti-SLAPP rule. And it is a procedural failure, and cert is also a vehicle available for procedural failures. So I think we are properly before this court, and I think that the matter should proceed before this court. The underlying case is about comments that Mr. Godwin made in a Facebook group engaged in a discussion about a letter that Mr. Michelini's lawyer sent to the city of Tampa about how Mr. Dingfelder, a city council member, should not be voting on matters related to Mr. Michelini's lobbying clients. This is like core local government First Amendment type issues. This is a Facebook discussion group, and the author of the article invited the public to comment on this article and whether or not Mr. Michelini was appropriate and his lawyer were appropriate in saying that Mr. Dingfelder shouldn't be voting on matters associated with Mr. Michelini's lobbying clients. And there was a back and forth exchange between Mr. Godwin and—
Is your position that this exchange is non-actionable hyperbole or opinion? Is that what your position is?
I mean, that is part of our opinion, but
Okay,
also—
But how about calling him corrupt?
He did respectfully, Judge Morris, if we look at the comments, that's not what he said. I think we look at the actual comments. These are written comments. So we look at the actual comments. What he said was the actual words of the comment are, and this is in the— I mean, I think this is a really important point, because the Mr. Michelini's counsel in their pleadings, both at the trial court and at this court, misrepresent what the underlying article says, and the contents of the comments that Mr. Michelini said. And what Mr. Godwin said. Mr. Godwin is responding to the news article, which mentions Mr. Michelini like 15 times, and then says, you have a lobbyist who is served without, who's hasn't registered as a lobbyist. And that's what this is about. It's about him not registering as a lobbyist. And the allegations are that Mr. Michelini was meeting with council members and not registered as a lobbyist. And that's what the contents of. The allegation of corruption, it says investigation into Michelini's corruption. It's the corruption is, and the context of it makes it clear, the corruption is a lobbyist meeting with council members. There is no dispute that Mr. Michelini was not a lobbyist. Was a lobbyist, but was not registered. He was not a registered lobbyist at this time.
It looks like we lost, Mr. Brack, it looks like we lost Mr. Geisler.
There he is.
Oh, sorry.
No, he's there. He's just messing with his camera, I think.
I think he dropped for a minute, but I do think he's definitely back.
Yeah.
Okay. I apologize. So what we have here is a situation where the comments are that Mr. Michelini was not a registered lobbyist. There's no dispute. During this period of time, he was not a registered lobbyist. He'd been a registered lobbyist before, he'd been a registered lobbyist later, but at this time, he was not a registered lobbyist. And
Is Mr. Michelini a public figure?
He is, but we don't need to get there. But at least for the purposes of this article, he's a public figure, because this article is about the letter that he and his lawyer sent to the city of Tampa.
Is he a public figure because the media chose to write about him?
No, Mr. Michelini, I would say, one, is in fact a general purpose public figure, and there's lots of evidence in the record about him. But with specifically as to this article, he is a public figure because he is suing. He has made an affirmative choice to sue a sitting city of Tampa council member. So he has thrust himself into this about a public access issue, right? He's claiming.
Is the logical extension of that anytime a private citizen seeks to vindicate, governments need to follow certain rules, that private citizen then becomes a public figure because they want to hold the government to certain rules?
Again, I think I don't have to go there, because here the article and the comments are specifically about the lobbying, right? So the issue that they wrote was, you should not be voting on these lobbying activities, on these matters involving my lobbying clients. And Mr. Godwin's comments are about the activities with respect to the lobbying clients.
So is he a public figure because he's a lobbyist? I mean, are all lobbyists public figures?
So again, I don't think we have to go there. I think that not all lobbyists are necessarily general purpose public figures. As to those issues where they are affirmatively lobbying, then they may be subjecting themselves to the public sphere, right? So the idea behind a public figure is it depends upon what it is you're doing. If I'm sitting at home not doing anything, I'm probably not a public figure. If I appear at a Tampa City Council meeting as a paid advocate and I'm injecting myself into the discussion on issues, at that point in time, for the purposes of those discussions, I become a public figure for that purpose, not a general purpose public figure, but for that purpose. And here, we're well beyond Mr. Michelini being somebody who's just sitting at home hanging out. Mr. Michelini is affirmatively the record is clear with the extensive involvement he has in the public sphere, and more specifically, the extensive involvement he had in the public sphere associated with lobbying, and even more specifically, the more extensive involvement he had in the public sphere associated with the interactions with Mr. Dingfelder, which is what this is about, right? The interactions with Tampa City Council member John Dingfelder and Mr. Michelini, who was suing him at the time, and then saying affirmatively and going out to say he should not be voting on these issues. That is absolutely a matter of public concern. Whether or not a sitting Tampa City Council member can vote on issues impacts everyone, and that is something that is a core First Amendment discussion topic, which is what is going on here. And this all relates back to the news report, right? The anti-SLAPP statute specifically says news reports are listed as the media formats, and that's at 768.295 paren 2 paren A lists news reports. And this all flows back to that original news report and the comments and the dialogue that's going on about that news report.
Mr. Brock, why was your client disguising his identity?
I think the use of nom de plumes is very common in the online sphere. We cited to the trial court wide uses of people using other names when they're appearing online. I think the president is known to have done that on multiple occasions. It is not an uncommon thing in the social media world to appear under a different name. It's something very common.
But that's the fact that it's common doesn't explain why someone would do it.
It doesn't really impact upon, I mean, respectfully, I don't think it impacts upon the First Amendment protections associated with it. The First Amendment doesn't require one to advocate solely in their birth name. But there's no evidence in the record as to why it was Mr. Godwin chose to operate in this instance under another name. But again, the First Amendment doesn't require that one specifically identify themselves with their birth name. It's not part of the analysis.
Is it too early for the court to have granted the motion to dismiss on the anti-SLAPP statute? In other words, it's very early in the ball game. There has been allegations of defamation. I mean, the court basically said, the complaint says this happened, and pretty much says that, there should be a little more discovery. For example, your client's deposition. And in Verariker, the Supreme Court struggled with this issue too. We all understand that the legislature has said, when someone brings a lawsuit that's in an effort to stifle free speech, the court should act quickly and knock that lawsuit out. But the Supreme Court also in Verariker also understood that it's not that easy to do all the time, that this early in the ball game. And that seems to be what was troubling the trial court. Because I'm looking at the court's order again and reading as I go through it. And I think that was the biggest problem the court had. You want to respond to that timing type issue?
Sure. So I think that in this case, there's really no additional discovery that's going to clarify anything else. This isn't a situation where we don't know what the statements are. The universe is a somewhat closed universe because it's a back and forth on Facebook, right? There's not a lot else out there beyond the statements on the Facebook posts. There's the original article, and then there's the back and forth. So this isn't a situation where there's other stuff that's really going to come in that's going to impact on that basic analysis of whether or not this is protected speech. It is. So I think that it's clear that there are cases where you might need discovery, but this isn't one of them. This is one of those cases where when you look at it at the earliest stage, it's one that should not continue to proceed. Again, this is a lawsuit about public discussion and public interactions. This is the most slappy of slappy litigation, and this is the instance where we should do that. Also, I will say that procedurally, this was brought as a motion for summary judgment, motion to dismiss or for summary judgment, and the defendant brought forth the motion, filed extensive supporting materials, and the plaintiff did not respond within the times set forth in the rule to the motion. So the new summary judgment rule requires.
Mr. Barrick, I hate to interrupt, but you are eating into your rebuttal time. So
I appreciate that.
proceed.
So I'll just say that the new summary judgment rule, this was also a summary judgment motion, and the new summary judgment rule required the defendant to file a timely response. They did not. I'll reserve the remainder of my time.
Thank you. Mr. Geisler.
May it please the court, Stephen Giesler, Bartlett, Loeb, Hides, Thompson, and Angelos for the respondent, Mr. Stephen Michelini. To address Judge Moe's citation to the Love case first, I am familiar with it, and I would cite to this language. This is the United States Supreme Court case that the Love Supreme Court in 2019 is quoting and relying on. Statutes relating to remedies or modes of procedure do not come within the legal conception of a retrospective law. What was at issue in Love was a legislative amendment, a statute that changed the substantive rights and the procedural rights that were attendant to litigants in those types of cases. And that's not what we have here. And you might ask, how do I know that? Well, because in two cases, at least, subsequent to Love versus State in 2019, this court has held that rules of appellate procedure that are changed during the pendency of a case do not apply retroactively. For those cases, I'll cite to Beck versus Wright, which is 353 Southern 3rd 664. That case is from 2022. This case concerned the recent amendment to the rule of procedure allowing punitive damage denials, or the denial of leave to amend for punitive damages to include them as non-final orders, which are subject to interlocutory appeal. In that case, this court said that it was bound by the rule that existed at the time that in that case, that the notice of appeal was filed. And the fact that the notice of appeal was filed prior to the effective date of the amendment to the rule of procedure meant that without exception, unequivocally, there was no jurisdiction to consider the appeal. The year before, in 2021, again, 2 years after Love versus State, exact same situation, this time about a sovereign immunity statute or sovereign immunity rule of procedure. In that case, the exact same setting on all fours, on all square, a situation where a notice of appeal was filed and the Supreme Court changed the rule during the pendency of the appeal. And I would point to court, this case is 325 Southern 3rd 334. And footnote 4 in this case, the court says, an added misfortune is that much of this analysis is likely no longer pertinent. As of January 23rd, 2020, the rule was amended to include 9 non-final orders that deny a motion asserting entitlement to summary judgment. We, however, are constrained to view the county's challenge through an extraordinary writ because the version of 9.130 in effect when the circuit court entered the subject order and the county filed its petition only authorized appeals of non-final orders determined that a party is not entitled to sovereign immunity.
Can you tell me the name of the case you're referring to?
Yes, Your Honor. This case is Sarasota County Public Hospital District versus Venice HMA LLC.
And
And
the first case was which one?
That case is the Beck versus Wright case.
And the page number for that one, is that 669 or I had my terrible handwriting, unfortunately.
665, Your Honor.
665. Okay.
Yes.
Thank you.
And this is the footnote 4 and footnote and for the Sarasota County case, I would switch in anticipating that this anticipated and obviates the petitioner's argument that this court should transform this from a petition for certiorari into a notice of appeal as such. Says this is footnote 8. The parties do not suggest we should apply the current version of Rule 9.130 retroactively. And it says, given the Supreme Court's direction in applying the rule, in enacting the rule rather, that the amendment shall become effective immediately upon release of this opinion, we would decline to do so if they had. And the case that cites is Love versus State, observing that the Stand Your Ground Law Statutes procedural amendment applies prospectively, in part because the legislation on its face is plainly forward-looking. So
an appellant in this case has no remedy?
That is correct, and this is I would say that the Supreme Court in deciding Verariker understood that dilemma. And I would point to
at least Justice Kennedy seemed to understand it.
He understood it precisely. He said that, and in his dissent, he said that in this case, because he recognized that the rule would not apply retroactively, he said, in this case, I would give this petitioner the ability to proceed under certiorari because he has no cognizable non-final appeal remedy. And I don't need to inform the court, who is much more well-informed than I am on these matters. Certainly, the majority saw that dissent before it published its opinion and made no attempt to qualify or to refute the idea that was actually the situation.
But an appellant could simply refile his motion below, right?
That is exactly the remedy. So to say that there's no remedy is with regard to this particular vehicle. But one of the last footnote in the majority opinion in Verariker addressed the respondent in that case's concern that there would be serial motions filed. And Justice Grosshans,
I think where you lost me is we've got the Florida Supreme Court saying that a new procedural enactment applies to pending cases if the posture of the case permits it. I think the only way that we go any further in the analysis is if the fulcrum on which this one turns is, what is the posture of the case, and has the case progressed so far that we cannot apply the new procedural enactment? Is that what you're arguing, that essentially once the notice of appeal was filed or the petition for certiorari was filed, then the posture of the case is such that it's too late to be able to apply the rule amendment? Because otherwise, nothing the second DCA has done can overrule Love versus State. And so we've got Justice Kennedy saying it is not a retroactive application, is what he said in Love, when you apply a new procedural enactment of any type to a pending case. That's not retroactivity, is undoing something that has already been done. So is it your position that the posture of the case component relates to the date that our jurisdiction was invoked?
It is, Your Honor, and a few points of contention there. One, Justice Kennedy's, and I might have been imprecise in my language characterizing Justice Kennedy's dissent. He did not talk about retroactivity.
No, I was talking about Love. I
understand that, but just to address the issue with Justice Kennedy, he said, given the absence of another means of interlocutory review. So he understood himself that the majority opinion in Verariker meant that regardless of retroactivity, that there was no prospective application of Verariker that would allow a means of interlocutory review.
But could that be why he was in the minority? I mean, could it be that everybody else in the court thought that's not true? No. Love or State means once that rule amendment takes effect, immediately upon the issuance of the opinion, that this could be converted.
It is not. Love versus State means that a statute that affects a procedural change can apply retroactively. There's a reason why this court, in all of its diligence did not cite to Love versus State affirmatively in both of the cases that I cited to you. And that's because it simply does not apply. These are procedural rules that were enacted through the Supreme Court as a matter of through its inherent authority to amend the rules of appellate procedure. I would note that the majority we cited one of the cases, the Getty's case, in our motion to dismiss and in our notice of supplemental authority. The majorities, the subsequent action of the Florida Supreme Court has to issue in at least 6 cases that I found orders to show cause why pending petitions in the Florida Supreme Court seeking review of anti-SLAPP petitions for certiorari should not be dismissed for lack of jurisdiction. Those are all currently pending. There have been responses and then replies to those responses, and the court has not made a decision on that count. But the critical date here, and we want to talk about Supreme Court precedent, I would cite to the Vasalinda versus Lozano case. That's 631 Southern 2nd, 1082. That's from 1994. And it simply stands for the proposition that jurisdiction is determined as of the date a notice of appeal or petition for writ of certiorari is filed. Full stop. That's the critical date. When you're dealing with amendments to rules, that is the date, as opposed to the Love situation where you're dealing with a procedural right that has been affected via a legislative enactment. And that's the distinguishing factor here.
Is that because jurisdiction is a matter of substantive law? I mean, is that where you're taking that?
I would say that it is inherent in the true understanding of what a pipeline case is. I would disagree with Mr. Barrick's statement from the outset that this is a pipeline case as it regards the amendment to the rule. The pipeline, this court has always understood the pipeline rule to apply to substantive enactments, substantive enactments of the Florida Supreme Court. That's it. That's the extent of the pipeline rule. And for that, I would cite to Rivera versus State, 235 Southern 3rd, 983. That's a case from 2017. And that's a case that describes the pipeline rule in the context of an intervening Florida Supreme Court decision. And that is the extent of the application of the pipeline rule. I would note and this is outside of the record, so in order to be precise, and I don't know an Aura Tennis request for judicial notice, but in these subsequent filings in response to the orders to show cause why the cases should not be dismissed, there has been quite a bit of back and forth about what exactly the scope of the pipeline rule is. And I, by virtue of my representation here, would say that there really is no question that the pipeline rule applies only to case law. It does not encompass within its ambit procedural rules. And I think that is consistent with Love versus State, and even more so is consistent with this court's decision not to rely on Love versus State to grant the remedies requested by the petitioners or the appellants in both Beck and in the Sarasota Hospital
Mr.
case.
Giesler, in reference to footnote 8 of the Sarasota County case.
Yes.
The majority in Sarasota County was saying that the parties didn't argue that the court should apply the current version of Rule 9.130. Doesn't that, by definition, mean that anything that the court said in footnote 8 about the application of that is not the holding of that case? Because Pedroza v. State is the case that tells us how to define what a holding is and what dicta is. And it says that it's what's before the court, the arguments are advanced by the court, what the decision turned on, etc. And none of those things would apply to footnote 8. Would you agree with that?
I would disagree. The question before the court and the holding of the court was whether or not this court had jurisdiction to consider the cause before it. And the fact that the rule did not have retroactive application was absolutely crucial to the holding. It's not dicta. The fact that footnote 4 says the exact same thing, I think that is indicative of the centrality of that holding with regard to, one, the proper or necessary vehicle the necessity of the proper vehicle in order to vindicate the rights of an appellant or a petitioner, and two, the fundamental nature of jurisdiction. I'm in an interesting situation here because I'll get on to the merits. My client might be better off for you to say that the court does have jurisdiction and to address this on the merits, because it becomes law of the case. As the court recognized, there has been no discovery in this case. And so a ruling on the merits here that this is absolutely the type of case that is outside, as a defamation case, outside of the ambit of the anti-SLAPP statute, would preclude the kind of serial or repeat filings of motions to dismiss or motions for summary judgment that the majority sought to brush away in Verariker. But in all candor, I think that the case law is actually quite clear. I think that the Florida Supreme Court's handling of Verariker, of the prospective application of Rule 9.130 amendment, and the Florida Supreme Court's decades-old holding about the time in which jurisdiction vests or does not vest, and then this court's recognition of the inapplicability of Love versus State. That statement in footnote 8, the citation to Love, means that the court was very well aware, not just because the court is diligent in doing its work, but also because it is very well aware of the application and the scope of Love, and went out of its way to distinguish a Love versus State situation through a substantive amendment from our procedural amendment via statute from this situation, or the one that was at issue in that case, which is an amendment of the rule. Moving on to the merits, as Judge Morris will recall, the order in the last iteration of this case that was overturned or was quashed said, full stop, that the anti-SLAPP statute does not apply to motions to dismiss. The trial court got it wrong in that situation. With the benefit of the 2023 ruling from this court in the last iteration of this case, the trial court did exactly what it's supposed to do in this case. In this iteration, the trial court, as is expressed in the order, looked outside the four corners of the statute and four corners of the complaint, looked to the filings of Mr. Godwin, and found that there still remained issues of material fact that precluded the entry of summary judgment. But even more than that, following this court's decision in McQueen versus Baskin, the very first question that has to be asked in an anti-SLAPP situation, and this is a quote from McQueen that says, the first question is whether the complaint states a cause of action for defamation. And in this case, on the face of the order, just as in McQueen, the trial court here said yes, that all the elements are pled. That the court also looked to the outside the four corners of the complaint and found that nothing that Mr. Godwin filed disturbed that holding, disturbed that finding. That's the end of the analysis here. With all due respect, the analysis of whether Mr. Michelini was a public figure is irrelevant for two reasons. One, this is not a mini trial. As this court held in Flynn versus Wilson, again, subsequent to the earlier Godwin opinion, the anti-SLAPP statute does not provide for an alternative or parallel or junior varsity version of summary judgment. All it does is say that the case can be filed, that summary judgment motion can be filed earlier than usual. The court said, in this case, said yes, but the record is still not developed enough to where I can, under the summary judgment rule, under 1.510, I cannot find, and I do not find, that there's an absence of issues of material fact. Therefore, I cannot enter summary judgment in favor of in that case, the defendant. This is exactly what is required of trial courts. It's exactly what happened in McQueen. Earlier this year, in the Mishiev case, this court held that the anti-SLAPP statute does not apply where a complaint pleads a cause of action for defamation or defamation per se. It does not hold that the anti-SLAPP statute does not allow for a kind of a mini trial or a preliminary trial on the merits here. And that's
The difficulty with that argument is almost all of these anti-SLAPP cases start with a complaint for defamation, which means the way to avoid the anti-SLAPP statute is to plead a case for defamation.
If a cause, well, you have to properly plead it. And because of this court, and because in part of this court's opinion in the prior Godwin case, the trial court does not just look to the four corners of the complaint. The court is required to look outside of the four corners of the complaint, probably exactly for that reason, and also to serve the purposes of the language of the statute, the plain text of the statute. The court did that here. The court did not just look to the four corners of the complaint, also looked to the filings of Mr. Godwin, looked and considered his argument that Mr. Michelini is a public figure and rejected that argument. In point of fact, it's irrelevant because the complaint at I believe it's paragraph 24 pleads a cause of action of defamation and defamation per se with actual malice, which is all that is necessary for a public figure to overcome the defense of the fact that a defamation plaintiff is a public figure. So even if he were found to be a public figure, it wouldn't matter for purposes of defeating the summary judgment motion or the motion to dismiss. But that's the push and pull that is inherent in this statute. The legislature wrote the statute the way that it's written. The governor signed it into law, and the Supreme Court now has interpreted in a manner that limits the circumstances in which a challenge can be brought. And in this situation, and pursuant to this court's holding, that is the law of the case, where the trial court finds that a cause of action for defamation or defamation per se has been properly pled, that is the end of the analysis. Now that analysis, again, not to beat a dead horse, requires an examination of the outside the four corners of the complaint. So it's different than a typical motion to dismiss. But the trial court in this case did this. So not only would I argue, or I submit that it is unquestioned that the court lacks jurisdiction to consider this on de jure jurisdictional grounds, but even the kind of relief that is being asked, even if this court did have jurisdiction to consider this case on the merits, the court would lack jurisdiction to, through its own precedents, to reweigh the factual analysis that, or at least it should give considerable deference and should not review de novo the factual determinations that are inherent in the order.
Okay, your time is up. Your time is up, so you need to wind up.
For those reasons, I would request that, or the respondent would request that the court dismiss the petition for lack of jurisdiction, and their alternative to deny the petition and affirm the ruling of the trial court. Thank you.
Thank you. Rebuttal?
I apologize, I had to unmute it.
Yeah, all the time.
I want to initially state that the law is not that if someone pleads a claim for defamation, the anti-SLAPP law doesn't apply. After McQueen was decided by this court entered the decision in Flynn versus Wilson, and Flynn was absolutely a defamation case. And that it's literally, I mean, that's what General Flynn was claiming, was that he was being defamed by Mr. Wilson. And the court in that instance absolutely engaged in the SLAPP analysis and said it was appropriate, and that's a defamation case. So, and this case is like Flynn. The difference here is we're not talking about national political figures, we're talking about local political figures. But to be clear, local politics and local political controversies are just as important to people as national politics and national political controversies. And those issues are entitled to the same level of protection by the anti-SLAPP statute. The decision of the trial court, and if you review the transcript, what it is the trial court said, she based the ruling on the fact, the trial court based the ruling on the fact that Michelini was not a public figure, which would be necessary to establish that defendant is protected by the anti-SLAPP, or it's constitutionally protected free speech because plaintiff's a public figure. That was the basis for the ruling. That's erroneous. That is not the standard. The trial court was wrong when it said that, and that was the basis for the ruling, was that that the anti-SLAPP statute only applied to public figures. That's not the law. That's not what was at issue in this case. That's not what the evidence showed. So it's wrong under any standard, including the clarification provided by the Supreme Court in Verariker. I think that the key thing really in this case for the court to be mindful of is there is a problem if this litigation continues and continues and continues. It represents a fundamental problem. And the way to stop that problem is to do what it is Verariker says, which is look at this case. And when we look at this case, we see that there is not merit and that the case should be dismissed. And so we would ask that the court reverse the trial court and allow this matter to be done.
Judge Northcutt, I just want to ask a quick follow-on question
Sure.
to Mr. Brock. Do you agree with Mr. Giesler's conception of love and whether love applies to procedural rules or only procedural statutes?
I think I don't see. I think the distinction is a false distinction between. I believe that it doesn't make any logical sense that that would be the distinction.
I mean, doesn't love say that no one has a vested interest in modes of procedure? I mean, like, doesn't that answer the whole question? I mean, modes of procedure or procedural rules or procedural enactments, they're one or the other, right? Right.
I would agree. And you know, some of this, I think, and this is sort of like big picture stuff, which would be an interesting discussion to have, sort of as a philosophical discussion. For a while, the court was using a procedure where they would ask the relevant committee to draft a new rule, and that sort of would make this process take longer. More recently, the court has gone to a procedure where they sort of instantaneously enact these new rules.
Judge Morris and I are somewhat familiar with the rulemaking process.
Yeah, so
in particular.
Yeah, so that changed to some degree in access. There was the change, for example, when they did the qualified immunity, when they said we're going to sort of import that federal qualified immunity case law into state court. In that instance, it wasn't an immediate enactment. It was they said, okay, rules committee, can you adopt a rule for us that we can evaluate and that then we can do it? But the substance of it was the same, which is there's now this mechanism, and we're going to use that mechanism, right? We're going to allow those interlocutory appeals of denials of qualified immunity in state court, which is what they did. And that case is that's the Tucker versus Rashida case, right?
And that's a situation where the court was exercising its Article 5, Section 2 rulemaking authority to create a procedure to give a procedural framework for the enactment of substantive law enacted by the Florida legislature, right?
Right. Yeah.
So, I mean, okay, that's all I had.
Yeah, and I appreciate the clarification, Judge Mo. I mean, I think it's I understand counsel's distinction a little bit, but I don't think it's a legitimate one. I think, you know, anyways, I appreciate the court's time. If there are other questions, I'll answer them.
Okay. That's the end of our docket. Thank you both very much. In order to leave our virtual courtroom, you click the leave icon in the lower right hand, should be in the lower right hand corner. There you go. With that,